Hello. Let's continue on the subject of general principles and characteristic of criminal law. Last I talked about the what makes an act to be criminalized and how do they constitute that this act should be criminalized. So today we are going to continue from where we ended.
So the other thing that has to be looked at when we are talking about the criminal, the principles and the characteristic of a criminal law, we are talking about also the real versus the crime. So regulating the activity or making something to be a criminal, it is also something that we have to. There are two things. There is what is called the real, and there is also what is called the crime. For example, regulating activities. So um, in the administrative law, we talked about some of the regulations and also the government agents that enforces certain laws. So now that is those are regulating activities. For example, safety, healthy and safety regulations. That is meant to try to regulate behavior, so that it does not bring harm to the community. So the action of the harm that may result into a certain consequences in the community may also be considered as a crime. So they are regulating matters that the Act of Parliament or the administrative law administers. That is also considered as the crime. Then let's look also at what is called the concept of criminal law. So we said that it's an act. The concept of criminal law or the characteristic of criminal law is that an act does not render one guilty. So doing something does not make one to be guilty. One only becomes guilty if the court is uh, if the court has seen what they consider as the mind of guilty. So a criminal offense or a criminal act is not just an action. One has done an action, no, but it is also the mind of doing that action. So something becomes a criminal when there is also the mind is judged. The mind, there was the guiltiness of mind. So an act does not make one guilty unless his mind is guilty. An act does not make one guilty unless his mind is guilty. So, doing something may not make you to be guilty of doing that act in the criminal offense. In a in a criminal offense, for example, one is throwing a stone and hits at somebody and so that will be considered basically people say he has committed murder, but one was just throwing a stone. So there is no mind of guilty in that way. It is an accident. So now that is going to be brought before court. Then the court is going to be able to judge whether that was intentional or it was not intentional. So a crime is the work of the court is to look at the action that one did, a misdeed. Was it intentional? Is there a guilty mind over it or not? So that is the one that makes a criminal offense. So an act does not render one guilty unless his mind is guilty. That's the principle of criminal law. Again, uh, uh, criminal uh, law also may, may also be something that they call the reasonable doubt. So there must be the evidence that this person intended to do this thing. That is when something is considered as a crime, and that is when now this is now a crime. So there are different types of criminal offenses, or their categorization. They have categorized the offenses like description of offenses in a criminal act, or in a act of someone. What will make one to be considered that he has committed a crime? So let me just give you um, about five um, types of determination of the criminal act, or types of criminal, what is considered as a criminal act. So there are different ways, or there are different categories of crimes. Number one, let's look at what is called resort crime. Resort crime is it is a crime that is brought, that is done, um, in particular, like bring a particular outcome. So the resort crime, it is the crime that should bring the particular outcome. It has to be, it can only be a crime when there is a particular outcome in that deed, or in that act. For example, murder. You cannot charge someone for murder if a person has not died. So even if a person gets a gun and shoots a person intending that that person should die, then that person doesn't die. That cannot be considered as murder. It can only be murder if that person is dead. So that is what is called resort crime. It brings it should bring a particular outcome. So if the case to be considered murder, there must be one must die. That is, now it becomes murder. So if it doesn't die, then it cannot be murder. So those are called resort crimes. Uh, the resort crime can only be considered as an action. Then, like rape, if there was no penetration, one cannot claim that I was raped. As long as there was no penetration and there is no evidence of penetration, then that cannot be considered as a rape. So it can only be rape if there was a penetration, the evidence of penetration, and there was that there was the penis penetrated into the vagina. That becomes now rape. Now, if there was no that penetration, and there is no evidence of penetration, that can never be called that there was rape. So that is called the resort crime. I know we may say, what about the attempted rape, attempted murder? Now, it is not murder. Attempted murder is not murder. Attempted rape is not rape. But it is it is also an action which is we are going to talk about later on. So the resort crime, in short, we are saying that it is the crime that should have an outcome. A particular outcome has to be said. This person has done this. then that becomes a crime. That is those that are the crimes which are called resort crimes. Then the other type of crime is the conduct crime. A conduct crime, it is the crime whereby the defendant's action is enough to prove that this person committed the crime, like dangerous driving. So now, dangerous driving, it is only uh, considered as a crime when your action has resulted into something. You were driving, then your driving led into hitting into a building. So then you are cited with dangerous driving. So that is a conduct crime. It's a crime which also can only be cited when there is an action, there is something that has the defendant's action is enough to prove. So there must be the enough to prove. So when you see someone cruising the car, then the traffic officers then stops this person and charges him with dangerous driving. That cannot be done. Because there is no action that can be proven that there was dangerous driving. So if they want, they should just use the cameras to go capture the speed and the speed limit. But that can never be cited as dangerous driving if that there is no outcome or there is no enough proof that this person was doing what is called dangerous driving. Then uh, the other types of uh, crime, it is affair uh, uh, crimes. So affair crimes, the crimes that crimes that may also be intentional. So the other crime is, we may call it the criminal or the crime of intention, uh, like taking something. Um, then the other type of crime, it is the crime which is we call a crime of recklessness. So crime of recklessness or reckless crime are the crimes of negligence. It's like you see a risk, but one sees the risk and doesn't take charge of the risk. Um, This can also be cited, for example, if uh, letting like whereby uh, I've left a child in a place, then a harm happens to that child. That can be a crime of reckless, which is negligence, and that can also be cited. So it is, you see that this person needs to be protected, then you don't protect that person, then a crime, something wrong happens over that person. Maybe that person is murdered, that person is killed. So that can also be cited as the reckless crime or crime of negligence. So it must be a conscious risk. This is where now you know that if I do this thing, or if I don't do this thing, this will be the result. So that becomes a negligence on your part. So anything that is going to bring harm, and which you know that if I don't do this, this is going to result into this harm, or this is going to result into a criminal activity, or whereby you are going to give room to criminal action to happen. That is also a crime of reckless. So then the last type of crime that I want to talk about is the offenses. Dishonest offenses. Um, which is also maybe mental state offenses. So the mental state offenses are the offenses which has to do with bribery. They have to do with dishonest acts, obtaining money by false pretense, conversion, and other offenses. So those are called dishonest offenses. They can also be cited as criminal offenses. So these are not the only types of offenses, but I want you to, when you, one of the major assignment or the major assignment that you are going to do, it is the way we did on the constitutional law, where you are going to look at the penal code and you are going to state the sections of offenses according to the Zambian Penal Code. So you're going to look at all the offenses that are contained in the Penal Code and you group them according to the way they are supposed to be grouped. So, in conclusion, we have looked at the concept of criminal um, law. Also, we have looked at how we are defining the criminal law. We have also looked at the concept of criminal law. Then we we are also looked at the types of criminal offenses. So there is we one thing that we have to know about the criminal offense is that there must be has to show the defendant was thinking. So one of the thing about a criminal law which considers that one to be reliable for conviction is that it has to show that the defendant was thinking and without reasonable doubt or standard. There is what is called the standard, objective standard. So the objective standard is the fault or restrict liability crimes. Uh, there is also what is called the or the which I've wanted to forget, the fault or restrict liability crime. That is one of the other crimes that uh, is when we say the fault or strict liability crimes, we are talking about those crimes like driving without a driving license or driving without an insurance. So that is a fault or strict liability crime. You are doing something that you are supposed to have the driving license when driving. Although this one it is considered as a finable offense, but also like driving without a lodge tax. You can also be cited as a criminal offense whereby you are not getting the tax, you are not paying the tax which comes to the misdeed. Oh, so thank you so much for having gone through with us, with me, on the introduction of criminal offense. So today we have looked at definitions and we have looked at the general principle of criminal law. Uh, so we tomorrow I hope that we should cruise so that we finish this course.